Now, of course, any contract can be written with new clauses in it if both sides agree. So if you need to put in if your clients, mostly your purchaser, needs an extended period or needs, something, they're still trying to get finance or whatever it is that's holding them up, but they want to sign a contract, but they want to do it conditionally, well then, yes, both parties can agree, and of course there can be a cooling off period or any conditions put into that. But the Conveyancing Act is all about the mandatory cooling off period. The 5 business day cooling off period is for residential land only. Okay, so residential properties and land under that 2.5 hectares. So they actually define what they regard to as rural, as residential land, what they regard to as rural, and that cutoff is that 2.5 hectares. Okay, so again, make sure that if you are dealing with the sale of rural properties, that there doesn't have to be a cooling off period in there, and because that's a question your purchasers are probably going to be talking to you about. And of course, if they need that, then that's a negotiation point between the vendor and the purchaser, and obviously you're the person in the middle here that's facilitating that negotiation. So make sure that you put that into your negotiations. So that's quite relevant, even if you're on the outskirts of Sydney, not necessarily the huge, 100 hectare properties or the massive stations, rural stations. But if you're dealing with the 10 hectare properties on the outskirts of Sydney, then you need to be aware that if you're selling over the 2.5 hectares, it is, some of these areas are rural residential. So you've got to look at that. There doesn't necessarily need to be, or it's not mandated or legislated that there needs to be a cooling off period in there. So that's a good one to remember when you are selling that style of property.